Well, good day everyone, I hope you've all been well. Today we're continuing from our previous video on Ms. Ntembu's 6 questions. But before diving in, here's a quick update in the case between Queen Kamaisela and King Misuzulu. Well, the Queen's application was dismissed, and all because she failed to prove a clear right and failed to demonstrate urgency. As previously discussed, these were some of the key requirements needed to be successful with an urgent application seeking a prohibitory interdict. Just something to keep in mind. As for today's question, what does it mean to be married in community of property? Let's unpack this. Marriage in community of property is the default marital regime in South Africa. And it simply means that the parties' individual estates become one joint estate upon their marriage, and they come to share ownership of all assets equally. But they also take on each other's financial liabilities. Therefore, if one spouse were to rack up debt, for example, then their creditors can claim from the joint estate even if the other spouse was initially not involved. This is because the marriage contract in nature is more than just a romantic decision, but a legal one. So to ensure a balance between shared responsibility and personal autonomy, major transactions like the buying or selling of a house, applying for a bond, or taking out a big loan will generally require both spouses' consent, for without it, such transactions may be deemed invalid, while your everyday expenses may not need such a consent. Sounds fair, right? But is there property that can be excluded from the joint estate? Yes. Certain types of property can be excluded by law or specific circumstances, even without the need of an antenuptial contract. For an example, any inheritance or gift received by one spouse before or during the marriage can be excluded from the joint estate, provided that the testator or the donor expressly stated this exclusion in a will or a deed of donation. This then leads us to the instance of when the parties undergo a divorce. Here the Divorce Act takes effect, and it regulates the dissolution of all marriages, including both civil and customary marriages. So yes, even if you were married in terms of customary law, the dissolution of such a marriage will require a court order. But moving on, upon divorce, the joint estate will be divided equally between the spouses, regardless of their individual contributions to the marriage. However, the court may order what we call a forfeiture of benefits where it is just and equitable to do so, such as when one spouse has unjustly reduced or diminished the value of the joint estate, or engaged in some gross misconduct. Alternatively, the parties may reach a settlement agreement that will dictate the manner in which the estate will be divided. So, what is the takeaway? Well, marriage in community of property binds spouses into more than just a romantic union, but also a financial partnership where assets and liabilities are shared equally. However, in the event of divorce, understanding the legal and financial implications is quite important. Hence, seeking professional legal advice in such instances is recommended to navigate the complexities of dividing the joint estate fairly and equitably. Well, that's it for today. Do indicate in the comments if you found this information to be helpful. I am eager to hear from you. For now, take care and keep well.